That's it. So, folks, that's the call. Please move along to your calendars. I ask that if you have multiple cases, attorneys, that you try to handle them as many as possible before you come to me, and then we'll address them in turn. I'll look at those defaults shortly. Thank you.
Your Honor, as far as Kiana Johnson, with this case with Pharrell, I'm in the hospital, so I'm trying my best from the hospital. I did submit a letter saying I was in the hospital. I don't have my ADA accommodation, so I'm not familiar with how this goes. Can you please tell me what's next?
Yeah, so all we would do, ma'am, and I really do pray for your swift recovery, whatever that may be, but ultimately it's virtual, so you would be able to still talk with that attorney in a private breakout room virtually.
Okay, I just need to know. Okay, so you all will do that. I don't know how to.
They will put you in a breakout room. You'll see an icon, and folks, this is for everyone. You ultimately will see an icon that says join breakout room. Do not leave the actual hearing, this Zoom hearing, unless I tell you to, okay? I'm the only one who can dismiss you. But ultimately, you'll be placed in a breakout room, and you may have to wait because one of the attorneys may have multiple cases, and then they will address your case in turn. Ms. Johnson, they may try to get to you sooner because you're in the hospital, but we will see. And then ultimately, you'll have an opportunity to determine if you want to settle the case or if you want to have a trial. Okay. And if you have a trial, we'll have to have that situated. So just be on the lookout, folks, for that icon to join, and then you folks are free to do so.
Sorry, that was my doctor. Sorry.
No problem. Thank you for being patient. If you can raise your right hand, we'll get you out of here. You swear affirm to tell the truth under penalty and perjury of the law?
I swear.
Counsel, give me 1 second. What are those terms?
Judge, this one's a little different, just to be kind of very open and frank with the court. So it's going to be an agreement. Both parties are going to dismiss with prejudice their claims and their counterclaims. Miss Johnson's lease ends on September 30th. She has agreed that if her stuff is not removed by September 30th, those items will be deemed abandoned.
Welcome back to channel where legal reality meets jaw-dropping drama. Today's case features what might be one of the most confusing tenant-landlord disputes we've seen yet, starring a self-proclaimed victim, a patient in a hospital bed, and a very patient judge trying to untangle it all. Meet Miss Kiana Johnson, the tenant who says she's too sick to handle court but somehow manages to attend multiple hearings and file motions while still in the hospital. Her landlord? Calm, collected, and just ready to move on. The judge? Walking a tightrope between compassion and courtroom control.
Is presented, they will sign it, and then after it's been signed, which I will prepare and give it to Miss Johnson by hopefully tomorrow, that the security deposit of $1,000 will be paid towards her, available for either pickup at our office, or I will be happy to FedEx it to wherever she wants me to FedEx it to. Does that make sense, Your Honor?
A little bit, but let me see.
Sure.
All right, Ms. Johnson, just to confirm, I just want to confirm the terms. The parties are both dismissing their cases, claims against one another, but ultimately you've agreed that you will move out your remaining possessions on or before 9/30/2025, and anything remaining will be deemed abandoned. However, if there is anything that deems valuable, the parties will hold and contact you so that you may retain it or get it. Moreover, the security deposit will be addressed upon your move out, which you guys will do a move out walkthrough as well. Counsel, is there anything else? No money judgment?
A negative. The security deposit's not quite right, Your Honor. So it's basically she's going to waive her right to, or we're going to waive our right to the security deposit. We're just going to give her $1,000. And she's going to sign a release, and my client will also sign a release.
Okay, so forgive me, Ms. Johnson. So in lieu of that, you will get $1,000 portion of the security deposit, or just $1,000 just in general.
Yeah, as a judgment. Yeah.
Yeah, and then that will resolve the security deposit issue as well. Anything else that I missed? I'm sorry. You guys got quite a bit.
Is that correct, Mr. Pharrell? It's not the security deposits. It's just $1,000 judgment, correct?
Right.
Well, it's not a judgment.
No. I didn't say anything about a judgment. We agreed on $1,000.
Here's where things start to get interesting. The agreement seems simple on paper. Both sides drop their claims, she gets her $1,000, and they walk away. But pay attention to the tone here. You can already sense confusion creeping in.ms. Johnson doesn't quite understand where the money's coming from, the lawyer's trying to explain it's not a judgment, and the judge is left playing translator between plain English and legal jargon.
All right, so Ms. Johnson, just so we're clear, I understand, I know Ms. Attorney Farrell is clear as well, but security deposit, they're not going to be keeping all of it regardless. Out of that, you're going to get $1,000 of the security deposit that you've already paid, and that is upon signing in a mutual release. Again, the parties are dismissing their claims against one another. You'll have to the 30th to remove your remaining possessions. Anything remaining will be deemed abandoned. However, they will keep it and potentially, if it's valuable, and contact you about it. Furthermore, upon that. Yep, that's what life likes to do to you.
Your Honor, if I may, just for clarification, she used the word judgment, and I'm no lawyer, but we didn't agree on any type of judgment. This is a mutual, amicable agreement.
I got it, Mr. Thomas.
Yeah, no judgment. We had an agreement.
I understand. But I need to wait for her to come back.
Yes, sir, I understand. Just
Ms. Johnson, can you unmute and turn on your camera? Here we go. Can you unmute for me?
Yeah, I'm sorry about that. I'm getting blood drawn and it just.
I get it. We're going to make it real quick.
Okay.
You agree that the terms are that you guys are dismissing your claims against one another, that you're going to be vacating on or before 9/30/2025, that any possessions remaining will be deemed abandoned, that anything that deems valuable, they'll contact you about. And furthermore, you'll do a final walkthrough where ultimately, after you sign an agreement, they will return $1,000 of your security deposit. Are these the terms that you've agreed to?
Yes.
And that, right there, is the calm before the storm. The first hearing ends on what seems like a peaceful note, both sides agreeing to walk away. But remember, in courtroom terms, agreement doesn't always mean understanding. Ms. Johnson believes she's owed more. The landlord thinks the matter's done. And the judge? He assumes everyone's clear. But when she returns for the second hearing, she'll claim that the agreement she signed wasn't what she intended at all.
And Ms. Johnson, Attorney Farrell,
Yes.
did you or Mr. Attorney Sinquet have an announcement?
Your Honor, I do. I have a pay and stay agreement on position number 4, and I still have one more tenant to talk to, and I know the court's considering position number 1.
Yeah, and so I just real quick so I can get to deal with Ms. Johnson. Ms. Johnson, raise your right hand. You swear or affirm to tell the truth under penalty and perjury of the law?
I do.
All right, so listen, I've read over your motion. I do see that the original judge had given an order for you to pay in the registry. I do understand that you had certain other conditions and that it was ultimately, that may have altered your ability to do so. And then some other things occurred. Those issues, though, don't necessarily materially address the issue of possession. They're totally fine for counterclaims, but they don't address the issue of possession. Obviously, your condition would really justify you leaving the property, right? So,
May I speak?
sure.
Okay, so as far as the position there, I did go into the property with an ADA need. I had an allergic disorder. That was addressed to the homeowner, and he said that he would make sure that there were no allergens in the home while I was there. A major allergen would be mold. That resulted from an unrepaired and unresolved and refusal to resolve without me. And that
Objection.
I would before.
So
Your Honor, we already dismissed the claims and the counterclaims. I think we're in front of the court on a motion to enforce what she contended is an oral agreement. It has nothing to do with everything that happened before.
Your Honor, I'm not.
Well, hold on. I see an order. I see an order for continue.
The judge is being unusually patient here. He's separating the emotional narrative from the legal reality, because in landlord-tenant law, possession is everything. Whether or not you paid rent, had mold, or filed motions, if you agreed to leave by a certain date, that's what the court enforces. But Ms. Johnson is blending two worlds, the personal and the procedural. She's bringing in medical hardship, emotional strain, and ADA claims, but none of that changes the signed consent order.
I see this oral agreement, but counsel, you're saying there's a different agreement? I mean, this alleged oral agreement where she's...
Judge, you signed an order. It should be in the docket. I can share the screen.
If I said I think I had the position first. He objected. Can I go back to my position?
Just hold on. I want to see what I'm looking at first. Okay, so there's a consent agreement. That's important. And so the consent agreement indicates defendant Keena Johnson and all others will vacate the property located at 2179 Diller Crossing, Tucker, Georgia, on or before September 30th at 5 p.m. and that anything left behind shall be deemed abandoned and may be removed without further order of court. Plaintiff sees anything valuable. Yeah, I feel like I remember this case. Further ordered and the judge, plaintiff's complaint, defendant's counterclaim. Yeah, so I understand what's going on. Today's the 30th, Ms. Johnson. You signed a consent agreement. I'm not trying to be difficult with you, but there's generally no appeals, of the consent and modification of such.
Your Honor, I'm respectfully asking under my conditions for a chance to speak.
Sure.
And I'm gonna speak by narrative, if you don't mind.
Well, I would ask that you just be respectful of the time and address specifically. So hold on. Let me ask this. Why do you believe that the consent order which you signed, saying that you would vacate by the 30th and dismiss all your counterclaims, why should that essentially be not considered in lieu of your signature on such, or in lieu of the agreement that I find that you've entered into?
Your Honor, the reason being, and before I go into that, I will say that I did ask for ADA accommodations. I am a disabled party. I asked for ADA accommodations that was requested on August.
And there it is, the first major curveball. Mold exposure allegedly triggering a learning disability. Even the judge pauses at this one. He's clearly baffled by the connection, and it's hard not to be. Now ADA accommodations are serious matters, but here the timing is suspicious. These requests come after the consent order was signed, not before. This moment highlights a recurring theme in courtroom drama. When people realize a deal didn't go their way, they often start looking for legal loopholes to undo it.
Authority to enter into the agreement that you said you had the authority to enter the agreement back on September 2nd?
No, okay, I needed, because I have a cognitive disability under stressful situations, this is why those accommodations were needed and the breaks.
Well, how do we address?
When I'm in another county, I get an ADA coordinator that I work with. I have been asking for a DeKalb County coordinator. I have not been given that. I've been told that we had to wait on the judge to at least address the ADA accommodations. They were asked for reasonable accommodations. Those were not addressed. Those were not addressed at the last hearing. That is not what I'm saying. I'm saying for me to continue forward in the manner in which we are, I'm going to put down that I'm not receiving those accommodations. I need to put that down on record. Part of those accommodations would be a support person for this hearing. Part of those accommodations would be breaks. I just got out of the ICU. My condition has been exacerbated. I've been in the ICU all week. That's another reason for the emergency continuance.
Continuance for what though? But why?
But that's why the ADA accommodations come in.
But we don't really need a hearing. And I'm not trying to be difficult, but you have to take this in consideration of how I'm viewing it. Before these things, or after these things were requested, you voluntarily entered into a consent agreement, right?
Your Honor,
don't cut me off. That's how you get nowhere. Why would you cut me off? That's foolish. So you've entered into this agreement on the 2nd of September, just less than 28 days ago, right? And
not this agreement.
Well, the agreement says September 2nd, and that you vacate by the 30th of September. I understand. Stop talking. I understand your physical conditions have changed because of your health, but that does not necessarily disregard the fact that you've entered into a consent agreement indicating when you would vacate. Your ADA accommodations are not relevant because really there'd be no need for a hearing based upon the agreement that you've already entered into. So I'm trying to figure out why we need to accommodate in those regards when you've already entered into this agreement indicating that you would vacate. You've created the time to prepare to leave. That was what your plan was.
Your Honor, may I?
Yeah, you can now, yes.
Okay, so Your Honor, I've had these disabilities for years. It's not just because of this. They just been exacerbated by this. The other reason is that when I had the hearing last time, I had the hearing from a hospital.
This is where the judge draws the line. He's essentially saying, you made a deal. I'm here to enforce it, not relitigate it. And that's the key distinction. Enforcement versus reconsideration.in court. Once you've consented to a written order, there's no takebacks, unless you prove fraud, coercion, or mistake.ms. Johnson keeps circling back to her disabilities, her hospital stay, and her stress. All real struggles, no doubt, but none change the legal reality. The judge is visibly torn between compassion and compliance, but the law doesn't run on feeling.
The agreement that he originally sent to me to sign for was about 5 pages long. There is history with this counsel, and he did not disclose that. I did try to disclose that with you before, which may be a conflict. The history being is that we're on a similar case in another county, and that similar case it has the same similarities, health-wise, landlord-tenant-wise, but that case is confidential. The reason being here is that I just found out today that he subpoenaed
Objection,
my medical
relevant.
records. He subpoenaed my medical records, and I just found that out today. I was just giving that
But let me
receipt.
let me
Yes.
stop. And I understand your situation, but I'm again looking at my notes from that hearing on the 2nd, and it says consent vacate by 9/30/2025.
And that's about all it says. But the agreement that you saw,
It says the property that you'll have and anything deemed, and they'll essentially keep a value and try to have you talk through counsel. So listen, I respect you and understand that you have certain conditions. I'd like to remind you that you're telling me that the property is uninhabitable while also trying to demand to stay in the property.
I'm not asking, Your Honor, I'm not asking to stay in the property. I've already addressed in my motions that I have signed a lease somewhere else. I have been out of the property
what is the
for the last
issue?
3 months.
So
The
what
issue
is
is that the issue is that I cannot, it's uninhabitable. I cannot go in and get my property, which includes my dad's ashes, my son's autism medications, all
Who
those
can
things.
go in? Who can go in?
The property I have tried to.
Are you there right now?
When I tried to go in.
Are you there right now?
I don't live there right now, but all our belongings are there.
Are you in the property right now?
What do you mean?
Are you physically in the property right now?
I am in the temporary housing property where I signed a temporary lease. I'm on my 3rd month of rent because that house is uninhabitable.
And that's fine, but that has nothing to do with ultimately you getting the remaining of your possessions out between the 2nd and today.
The agreement.
So listen, respectfully, what I do know is that you've agreed to vacate. There's nothing in here indicating that you are required to pay rent or anything like that in the consent agreement. So Attorney Farrell, I'm not sure about the writ that's been requested because I believe the writ indicates that she's missed a payment. Now, I believe that may be associated with a prior order.
This is the emotional climax. Ms. Johnson insists the agreement she signed isn't the same as what was discussed in court, a claim that's nearly impossible to prove without a transcript or recording. Notice how she references verbal agreements and layman's terms. That's courtroom code for I didn't understand what I signed. The landlord's attorney, however, keeps things cool and factual, no emotion, no engagement, just legal procedure. And that's often the smartest play in situations like this. The judge, meanwhile, is holding back frustration. He's seen this dance before, and he knows where.
Further order in the judge, parties will sign a mutual release and will not cover damage of any of those property defendant can. So you guys never signed that release. I see that was I guess that's the oral agreement that you guys have been referring to.
I'm trying to continue.
Be paid $1,000 from her security deposit for fitting the remainder.
They added language to that consent agreement that was not part of the agreement is what I'm trying to get to.
Okay, and which part?
It's the part where they say that the $1,000 security deposit, they have, when they presented me with an agreement to sign, the release to sign there was no contingency basis, first of all, for me to sign that release in order to get that $1,000, but they put that down there. They also were supposed to, if I didn't get all my things out, given the consideration of the situation, they were also supposed to, they agreed that I would give them a forwarding address. They would allow me to get some of the most personal, valuable things back. And so they changed that.
It says if plaintiff sees anything valuable. Well, and that's not what it says in the order. It says if plaintiff sees anything valuable, plaintiff will reach out to the defendant through counsel to have it picked up.
No, they agreed not to pick it up, that they would give it to an alternative address. They would send it. The other thing is that
Negative, Your Honor.
So Ms. Johnson, I'll be frank. I'm
going to file a motion today. Go ahead.
You can do what you want because that's what's legal. I'm not.
But that's not what the agreement. My argument, Your Honor, respectfully, is that there's more to it than that. That is not what the agreement was. I'm
just telling you. You don't. There's nothing that you're saying that doesn't seem as if you don't grasp what I'm saying or that you need aid. And indicating what you're telling to me is that you have an issue with this particular order. One of which I'm not quite sure because what you've already said is that what's on this order, which is one page, right? One page, So I'm not sure about what else you're talking about, but the order that I'm referring to is 1 page, and I've already read it, and it's a consent agreement.
There's one more thing, Your Honor, if you let me. On the order, when we talked about this, the security deposit, it was in lieu of the security deposit. He was not allowed to go and what he tried to put in the new agreement for me to sign in order to get the $1,000. That was cost to help me move out, not for him to move me out, but for me to be able to get my things out.
Well, let me just read it so I make sure that you are reading. So it says in this last portion, further ordering the judge, the parties will sign a mutual release agreement. The mutual release will not cover damage, if any, done to the property by defendant or any other occupants. When defendant Kiana has signed the mutual release, she will be paid $1,000 from her security deposit, forfeiting the remainder.
No, Your Honor. I still have to sign their version of a release to get that $1,000. I was not able to do that because their version of that release does not state what is on that order. It actually states that I'm sorry. This is where I probably need a break, but I don't have those accommodations.
Well, how about we do that? Why don't I give you a break and I'll move on and I'll come back.
I can give you.
No.
And that's where this wild courtroom ride comes to an end. What started as a simple tenant dispute spiraled into a debate over ADA rights, medical conditions, and verbal misunderstandings, all orbiting around one simple agreement: move out by September 30. In the end, the judge held firm. The law favored the signed document, not the emotional testimony. It's a reminder that in court, clarity beats chaos every single time. So what do you think? Was the judge fair here? Or should he have shown more leniency given her health claims?